Our paper's action on the assumption that the subject of overlapping jurisdiction can only be insufficiently understood in its complexity if the perspective is kept restricted to the relations of courts or other institutions of jurisdiction. The reason is that we often deal with organizational and substantial conglomerates which not only include jurisdictional but also other institutions. Overlapping jurisdictions are part of juridical systems of decision-making. These systems are characterized by three attributes. Firstly, it's difficult to determine the function of some institutions according to the traditional triad of jurisdiction, legislation, and executive. Either because their task cannot clearly be subsumed under conventional definition of task, or because they are multifunctional institutions. Secondly, jurisdiction, legislation, and executive are frequently interrelated in a specific manner which doesn't correlate with traditional mechanisms of coordinations. And thirdly, a further level of overlapping has to be considered, the overlapping of state and non-state. Thus, the relationship structure become visible in which private, semi-state, and non-state actors are taking their part in equal measure. Such constellations are mainly suspected in the present in which state control ambitions are beginning to totter, in which large sectors of public tasks are privatized, and in which the state monopoly of organizing is eroding. However, our paper is arguing that we can observe options of structuring at this point which are available for every modern society. And by that we mean societies which have been in existence since the 19th century. The access to these options can always be witnessed in cases in which new social political problem complexes challenge the conventional legal and organizational system, in which new actors with their own interest, with their own institutions assert their claims, and in which new innovative solutions are necessary. We try to illustrate this by means of two examples. The first is located in the early 20th century, the second in the early 21st century. In the following presentation, we want to sketch the respective social-political challenges and the organizational structures and the interaction mechanisms of these juridical systems of decision-making. The first example is the joint self-government of health funds and doctors. Firstly, to the legal and social-political background. In 1883, the general compulsory health insurance for workers was established. Hereby, the economic framework in which the medical practitioners operated changed seriously. Before 1883, the relationship between doctor and patient was based on a contract between both. After 1883, the workers were insured by health funds. These funds were responsible for the payment for medical service and were the doctor's new contractual partners. Thus, a new payment for medical service, thus a new actor came into play, and it was a mighty actor, because the number of insured patients soon exceeded the number of private patients. Shortly, doctors were unable to manage without treating those newly insured patients, and therefore the doctors were dependent on orders of the funds. Thought it was only possible if the funds offered them to enter into an agreement. Since the health funds represented the majority of potential patients, they could dictate the contractual conditions. They preferred an annual lump sum payment on the basis of an as low as possible rate. This was possible because the legislator had refrained from making provisions for the contract design. The doctors, however, strived for a fee-for-service on the basis of as high as possible rates. Thus, the conflicts between the two groups were predestined and began immediately after the establishment of the health insurance. Per se, the doctors had a weak position because as single actors, they had no means to combat the monopoly power of the insurance funds. Thence, the strategy was to band together in associations, to develop joint guidelines, and to try enforcing them by means of collective actions. Such collective actions were, for example, strikes, boycotts, and the punishment of colleagues which had subjected to the funds disadvantageous contract conditions. These conflicts intensified more and more and lasted till the first decade of the 20th century. These also gave the public and the government reason for concern because they affected the new system of healthcare. Therefore, the state tried to push both parties to enter into an agreement. Due to the governmental pressure, the umbrella organizations of the medical practitioners and the health funds reached an agreement in 1913, the so-called Berliner Abkommen. This agreement didn't contain any substantial provisions for the subject matter of contracts, for example, referring to the modalities of the service performance, the structure of the fees system, or the amount of fees. The agreement ranged solely over the establishment of joint boards based on the principle of parity, which were responsible for the preparation of contracts and dispute resolution. However, the mutual coordination within the framework of this agreement worked only insufficient. After the end of the First World War, the conflicts intensified again. Since the parties were not able to solve their conflicts, the German government enacted the Verordnung über Kassenärzte und Krankenkassen, Regulation on Panel Doctors and Health Funds, in 1923. As a result, the joint self-government of doctors and health funds was based on public law. Below I want to sketch which organizational structures and mechanisms of interaction were created by this law and how out of this complex system was set up, which contained not only norm setting but also jurisdiction and administrative elements. Law of 1923 took up the structures of the Berliner Abkommen, however, generated a more differentiated system. At first, a brief overview. The Reichsausschuss für die Ärzte und Krankenkassen, Imperial Committee for the Doctors and Health Funds, became the central coordination body. Its main task was the passing of guidelines which concerned the terms and conditions of the contracts and the admissions of panel doctors, among other things. Vertragsausschüsse, contract committees, were responsible for the preparation of the contracts on a regional level. In case of failing consent, Schiedsämter, arbitration offices, had to decide. They were also responsible to decide conflicts on closed contracts and questions of admission. The Imperial Arbitration Office, Reichsschiedamt, acted as an appellate court. Furthermore, there were further institutions existing, as for example, the Zulassungsausschüsse, admission committees, or the Arztausschüsse, doctors' committees with special administrative tasks. At first glance, we deal with an organizational system in which tasks were clearly allocated according to conventional functional patterns of legislation, norm setting, jurisdiction, and administration. The Imperial Committee, with its guideline competence, was quasi the legislative organ. The arbitration offices and the Imperial Arbitration Office acted as a jurisdiction and the other institutions as administrative bodies. However, this is only a first superficial finding. At first, the organizational system of the joint self-government was a parallel system beside the state organization, while it was not always clear where the border between the state and the non-state sphere ran. Secondly, it was often controversial to what extent the tasks of the particular boards could be attributed to certain functional categories. And thirdly, the competence delimitation between some institutions within the self-government organization and external institutions were not always clear-cut. To what extent the joint self-government of the doctors and health funds was part of the state or the non-state sphere was seen differently. The Imperial Committee consisted of 13 members. 3 of them were nominated by the Minister of Labor and subject to his orders. The other 10 members were nominated by the umbrella associations of the doctor and health funds, respectively half the number of each. Due to representation of state officials, the Imperial Committee was classified as a state authority with self-government competences. The same applied to the Imperial Arbitration Office, which consisted of 9 members. 3 of them were nominated by the President of the State Imperial Insurance Office, respectively 3 each by the interest associations. No consensus existed in respect of the classification of the arbitration offices, which consisted of 3 members nominated by the state and 4 members nominated by the interest organizations. Partly they were classified as state authorities, partly as organs of societal self-organization. Finally, the contract committees, in whose decision-making no state officials participated, were viewed as purely private bodies. Thus, we are dealing with an organizational system in which the boundaries between the state and the non-state sphere were partly blurred. The functional attributions were also partly controversial. The main task of the Imperial Committee was the enactment of guidelines. It was clear that this function was not legislation in a conventional sense. But was it at least law-giving in the broader sense? The answer to this question was dependent on whether the guidelines were classified as law. But especially this point was heavily disputed because of the limited binding force of the guidelines. They were only mandatory for the arbitration office and only in such cases in which particular reasons didn't conflict with the application of the guidelines. Also, as to the function of arbitration offices, a differentiated approach can be found. So it was differentiated, in the view of legal literature, it was crucial which matters they were dealing with. So it was differentiated between the task of conciliation in case of negotiation processes relating to future contracts, the task of jurisdiction in case of conflicts over existing contracts, and the task of administration in case of conflicts over questions of admission. Doing so, it was acknowledged throughout that it wasn't possible to maintain this differentiation thoroughly in practice. In conflicts over future contracts, a juridical rationality could prevail, and in conflicts over existing contracts, extra-legal considerations could dominate. Also, the classification of the contract committees as administrative bodies was problematic. On the one hand, they were supposed to assist the parties up in conclusion of the contracts. On the other hand, they were expected to enforce public interests. Unclear or disputable competence assignments provoke competence conflicts. This could also be observed in the case of joint self-government of doctors and health funds. It can be seen first in the internal sphere of the self-government. So the question arose whether proposals of the contract committees could be ignored during the negotiations over the contract conditions if the conflict was pending with the arbitration officers. In such cases, the function of both boards overlapped because both boards were supposed to act as conciliators. It was also controversial how the guideline competence of the Imperial Committee and the central jurisdictional competence of the Imperial Arbitration Office related to each other, because it was stated that the Imperial Arbitration Office repeatedly ignored guidelines of the Imperial Committee and, allegedly due to the peculiarities of the cases, set own standards. However, the delimitation of competences could be even more complicated if it was about the relationship to institutions outside of the organizational structure of the joint self-government. This concerned mainly matters of jurisdiction. Three actors came into play here: the arbitration offices, the ordinary courts, and special arbitration bodies, which were established on a voluntary basis. It had to be differentiated between different matters in dispute. The arbitration officers were responsible for disputes in negotiation processes relating to future contracts. In the case of disputes relating to existing contracts, another differentiation had to be made. The arbitration officers were responsible for the so-called obligatory part of the contract, in which only the contracting associations were obligated. The ordinary courts had, on the other hand, to decide on the so-called the normative part of the contract, which constituted rights and duties of the individual doctors and health funds. Moreover, disputes regarding property and disputes which did not regard property had to be distinguished. In the first case, the ordinary courts decided. In the second case, the arbitration officers were responsible. However, the former was only the case if the parties had not stipulated the responsibility of a special arbitration body. In that case, the arbitration agreement barred the way to the ordinary courts. Furthermore, it needed to be clarified to which extent the ordinary courts were bound to the decisions of the arbitration officers and which institutions were responsible for the enforcement of the judgments. For all these questions, the law had only provided clear rules to some degree. Partly, law amendments were necessary, partly the Imperial Committee tried to solve problems by means of guidelines, partly the jurisdiction of the Imperial Arbitration Officers tried to clarify the points at issue, partly the legal literature offered appropriate proposals. Thus, from a special normative order for the collective contracts of doctor and health funds, an institutional arrangement resulted in which the boundaries between state and non-state and between jurisdiction, legislation, and administration blurred. However, the result was also a blurring of the boundaries between different normativities. Just because the new organizational system tried to integrate the specific needs of a societal sector better than within the existing framework of state jurisdiction and administration, the rationalities of this sector had to be incorporated in the decision-making program of its institutions. These rationalities could be found in expediency considerations which manifested themselves in the written law only incompletely and aimed at an appropriate balance of interests of the parties on the one hand and at an adequate consideration of public health policy need on the other hand. In this sense, we can speak of a multi-normative order as a coordination regime for the adjustment of different normativities. Thanks.